Ontario has the second highest rate per capita of police-reported human trafficking amongst all of the provinces, and over 65% of trafficking cases are in Ontario. But what does human trafficking have to do with debt? Believe it or not, there is a strong connection. I have a guest on the show with me today to discuss the connection, and we'll discuss new legislation to protect victims of human trafficking from financial fraud. Let's begin.
This is Debt Free in 30. Here's your host, Doug Hoyes.
Obviously, human trafficking is horrific. The victims suffer greatly. I interviewed a survivor on a previous podcast, episode 344. I'll put a link in the show notes. That's a difficult episode to listen to, but it gives a good introduction to how human trafficking and sexual exploitation happens here in Canada. To make matters worse, victims of human trafficking often end up with debt problems. How does that happen? My guest today is Richard Dunwoody, who has many decades of experience in the credit industry. He was a guest on this podcast, episode 41, back in 2015, almost 9 years ago. I'll put a link to that episode in the show notes. Richard did a lot of work talking to many legislators to introduce legislation to protect victims of human trafficking from coerced debt. It hasn't received much coverage in the media, but on December 4th, 2023, Bill 41, Protection for Coerced Debts Incurred in Relation to Human Trafficking Act, received royal assent in Ontario and became law. That's poetic justice because December 4th happens to be Richard's birthday. So, what's this about, and why am I doing a podcast about it? Well, I've been watching the progress of this bill for over a year, and today I have an interview I recorded in my Toronto office on March 1st, 2023 with Richard Dunwoody. We were waiting to see if the legislation would pass before releasing this interview. Now it has, so today I want to play you some excerpts from my conversation with Richard. The first question I asked Richard, what's the connection between human trafficking and debt? Well, he told me that traffickers will use the victim's identity
or existing credit facilities allows the facilitation of the trafficking. It pays for the hotels, it pays for the escort advertising that needed to be done, cell phones that are used to sell their victim. The actual other side of it as well is that traffickers will use credit facilities for their own personal benefit, buy a car, buy a game machine, etc., etc.
That's obviously horrible, but that's what happens. Think about it. Why would a human trafficker engage in something as horrific as human trafficking? They are evil people and they do it to make money. The trafficker collects the money earned by the victim, but they also take over the credit cards that the victim has, and perhaps they even coerce the victim to apply for new credit. Once the trafficker has access to that credit, they can spend it, as Richard says. Here's another scary stat. It is estimated that a trafficker will generate between $250,000 and $350,000 per victim. And some traffickers sell multiple victims simultaneously. Human trafficking is horrible, and for the trafficker, very profitable. So let's talk about the legislation. As I said, we recorded this interview last year before the legislation was passed. Bill 41 was an act to amend the Consumer Reporting Act and the Prevention of and Remedies for Human Trafficking Act, with respect to certain debts incurred in relation to human trafficking. In other words, Bill 41 amended two existing laws, one of them being the Prevention of and Remedies for Human Trafficking Act. As I said, this legislation is very short. I'd like to read two short paragraphs. Despite any other act, no person or entity shall, through any means whatsoever, knowingly collect or attempt to collect a coerced debt. Where the existence of a coerced debt has been established, no person or entity who is determining whether to provide a debtor who has been subjected to human trafficking with credit services or products shall take the existence of the coerced debt into consideration when making that determination. Okay, so The legislation uses the term coerced debt twice in 2 paragraphs, so it's an important term. I asked Richard, what does coerced debt mean? Here's his answer.
So coerced debt is essentially persuading or getting somebody to do something through force or threats. And so when we talk about debts that I deal with survivors and place into perspective, and that I've worked in 608 cases in just the last 3 years, wow. The size of the problem. The average survivor will face $23,000 in fraudulent and coerced debts.
Is there a difference between fraudulent and coerced debt?
Well, fraudulent debt will be debt where the survivor was not involved. So the trafficker had used their identity to get credit cards through an online mechanism or a loan online, and that
stole their identity, whatever. Yep.
So coerced debt is where they're forced to do it. Then if, in the early days when I was doing this, I would ask a survivor, so, why did you do that? Why did you go and apply for that cell phone? And they would say, because it was easier. And what that means, interpretation, is that if they didn't do it, they would have suffered physical abuse and then would have had to have gone and done it and obtained that credit as well. In almost every case that I deal with, there are non-reimbursable provincial medical expenses that they face from the physical assaults that they endure in that 3.5 average year that they're trafficked.
Wow. So they have no choice. It's
simple.
Pretty simple. Pretty simple as that. So, okay, what then is the purpose of Bill 41? Why is this before the legislature now?
So, since 2019, I've worked with many Canadian creditors, and I can't thank them enough, for working and developing a process that's compassionate, ensures the victim is not re-victimized by having to tell her story and over again to different creditors, and provide relief. So this bill is not directed at those creditors, and it changes nothing that most of those all of those creditors are actually doing.
And just let me pause there then to emphasize that point. So your history, going back many years, was in the collection industry.
In the banking world, yes.
And the banking world, yes. So you actually understand this from that point of view. So you understand how that all works. And so what you have done based on your, I'm not going to say many decades of experience because I'm sure you're only 30 years old, but you got a lot of contacts in the industry. You went out and talked to all the major banks, all the major lenders, and you said, hey, people, here's what's happening. Can you step up to the plate? And the vast majority of them have.
Correct. Absolutely.
They have said, yep, okay, we understand the issue. We're not going to be pursuing people for these kinds of issues. So that's good.
Right.
So if the big lenders are already on side with this, why do we need this legislation?
We need this legislation for the many other lenders, okay? And it's generally the smaller type lenders, companies such as resellers of utilities, and that small online payday loans, property management companies, landlords, etc., that that will use credit reports as a mechanism to force the survivor to pay. If you don't pay me, then it's not coming off your credit report. None of these creditors would ever pursue litigation against these individuals, against survivors, because they know, number one, the brand is going to hurt. Number two, they're not going to be successful. So what they've been doing is using credit reports and the collection item on the credit report as a means to coerce payment. So earlier we talked about the definition of coercion, and that the irony is not lost on me on the need for this bill.
Because the creditors are then coercing the debtor.
Some creditors.
Creditors. And you've already explained that. It's generally not the big banks, the big lenders that were doing this. they're on side with this, thanks to your efforts to, talk to them over the last 2 or 3 years. But it's, as you said, the smaller lenders or the lenders where it may be a one-off incident, like the landlord who's never run into this before. And it's like, well, if you don't pay me, it's going to be on your credit report. So what this legislation, and the payday loan companies, which we're not going to discuss them because we don't have 3 hours here. So the purpose of this legislation then is they are not able to use a credit report as a form of coercion.
Correct.
Pretty much that simple. Okay. Now
this bill too, Doug, and I should step in. Okay. This bill is similar to legislation in the U.S. that was passed unanimously through the Senate and Congress, signed into law, called the Debt Bondage Relief Act. And so working with that is what led me to bring it here in Ontario. Difference in Canada is credit reporting legislation is regulated provincially. Mm-hmm. That's why I have to go through all the provinces.
Right. And so is Ontario the first one?
It is.
And presumably if Ontario passes this, then the other provinces will go, well, okay, Ontario is the biggest province.
Right.
We'll probably fall into line.
It's make sense legislation. Mm-hmm. And not undermining the great work that Lucille Collard and Laurie Scott, Chris Glover, Mike Schreiner have done. It's make sense legislation. Mm-hmm. Okay. I'd like to see which MPP will stand up and say no.
Yeah. And you don't expect there will be any.
I don't.
Yeah. And again, if all parties are supporting it, then it's kind of a no-brainer. Now, so when I read it, no person or entity shall take the existence of a coerced debt into consideration when determining whether or not to provide the debtor with any services. So, of course, me, everything's about me. So I'm sitting here thinking, I'm a licensed insolvency trustee. Someone comes in to see me and says, I've got a bunch of debts. And I go, oh, okay, well, one of the possible solutions is a consumer proposal. What this legislation says is the coerced debts would not form part of that consumer proposal. Is that your interpretation of what this legislation would say?
Absolutely. And legislation also, and there's going to be a little change to it, the legislation and the wording, right, is that a creditor cannot knowingly accept or attempt to collect money. And the key word we need to put in there is knowingly, right? Now, for you to do a consumer proposal, if your client doesn't disclose to you, okay, that the debts arose from trafficking, can't hold anybody liable for, responsible for, guessing.
Those were comments Richard made back in March 2023 when we were reviewing the draft legislation. Richard alluded to the fact that the legislation would be updated to add the word knowingly, and it was. So here we are in January 2024, and the final legislation does say that. No person or entity shall, through any means whatsoever, knowingly collect or attempt to collect a coerced debt. Now, as an aside here, let's talk about me. As frequent listeners to this podcast know, my firm, Hoyes Michael & Associates, does consumer proposals and bankruptcies. If someone has a lot of debt that they can't repay, a consumer proposal or a bankruptcy is an option we discuss. But with this new legislation, if someone consults with me and they tell me that they have coerced debt as a result of human trafficking, I can now tell them that a consumer proposal or bankruptcy may not be necessary. No entity can knowingly attempt to collect a coerced debt, so if the debt can't be collected, a consumer proposal or bankruptcy is not necessary to eliminate it. So we've talked about licensed insolvency trustees, like me. If most or all of the debtor's debt is coerced debt as a result of human trafficking, a consumer proposal or bankruptcy is not necessary. We've talked about the big banks. As Richard said, all but one of the big banks were already on side with this even before the legislation was passed, so this legislation was not aimed at them. Which begs the question, who is this legislation aimed at? So my next question for Richard was, what other agencies or institutions or entities are impacted by this legislation? Here's his answer.
Entities are out there involved in practices or businesses of advising consumers facing financial difficulty. So we call our debt advisory companies credit counseling, organizations. And I've seen it far too often in just the last 3 years of what these entities are doing to these young people. Just remember, Doug, that 95% of victims trafficked in Canada are Canadian-born. Let's dispel that myth that they're coming from, other regions outside of Canada. The average age of a survivor that I work with when they were first trafficked is 14 years old. Okay? It's the average, the average age. So knowingly, the key word is knowingly, placing these young people on debt management plans and credit counseling is absolutely false. It's wrong. It's incorrect. And I've seen them over and over again. And it takes me twice as much work to resolve those issues with the creditors. There's debt that none of those organizations and even yourself as a trustee, can address. Government debt, and the bankruptcy, a consumer proposal, and that in credit counseling debt management plans, they do not address the government debt that's
You're
sitting
specifically
there.
talking about things like a student loan that's 2 years old, for example.
And they're talking about a student loan. Right now, we're seeing it. The catalyst is the CERB, process where traffickers were getting the CERB checks, unbeknownst to the victims, and now the CRA is coming back after these victims, now survivors, saying you collected all this money and
you got to pay it back.
Provincial Offences Act fines, those types of things. The young lady. John wasn't going to pay her, and she knew that if she didn't come back with no money to her trafficker, she was going to get beaten. So she caused a disturbance. The hotel called the police, and the police charged her, and she had a $300 ticket for disturbing the peace. These are the things that none of these, okay? But even further, and we've seen in these debt advisory services, many of them operating, offshore, from other countries, where they've set up these young people and that survivors in a consumer proposal where they've charged them what I consider an outrageous fee, upfront fee, and then referred them to a trustee. And I think the vast majority of trustees don't deal with these companies. Okay, these types of entities. There's a handful that probably prefer profit over doing the right thing. I get that's the society we live in, and we have those people in business and that. But I've seen where survivor had $580 in government assistance coming in, and the debt advisory company took that $580 for 6 months and then referred her to a trustee. And all of those debts, I know I could have been removed. Credit counseling agency that was referring a survivor to a trustee, and at the last minute, she decided to reach out to me, and didn't go through that process. $8,000 is what she owed. I had those debts removed in 24 hours. If she'd gone through that bankruptcy or consumer proposal, and that her life would have changed for the worse. She completed an entrepreneur course. She's doing amazing, and she was running her own catering company in downtown Toronto. Those are the successful outcomes that we need to see from these young people, not re-victimizing them to make a few dollars, for our business. So that's another target.
And what you're talking about here is not theoretical. These are actual cases you've actually seen in real life. And obviously I've, preached against the debt consultants for many years, and it falls on deaf ears, but I keep trying. But yes, that's the how debt consultants work, whether you've been trafficked or not. It's, hey, we're going to charge you a big upfront fee. We're going to take fees from you for 6 months or as long as we can, and then the proposal starts, and we turn you over to the trustee at that point. And I mean, I think that's evil, but it's even more evil when the debts that you've got are debts that, had they gone through someone such as Victim Services, could have made a few phone calls and had the debts like wiped out. That's what you're talking about, right? Like, we are not going to collect them. We are not going to negatively impact your credit report as a result of that.
Right. Legitimate debt. I've got to prove it.
Yep.
Me saying that this debt arises from trafficking is not acceptable, and my background in the banking, I wouldn't have accepted it. The U.S. legislation, the Debt Bondage Repair Act, provides for self-attestation. And in putting this legislation together and working with the MPPs, I don't agree with that. Okay? I think there has to be a process to prove that the debt aligns with human trafficking, and that's what we've done for 3 years with the major creditors, so that's why I say nothing changes. But no, these are absolute, examples. The young lady, last year, they dealt with 3,000 credit counseling organization. Okay, dealt with 3,000 of her $52,000 of debt, but she couldn't make the payment of the debt management plan, and I got involved. I removed all of that debt, $52,000 worth of debt. I was able to get the two creditors involved, to return the funds that she paid during that debt management plan. The only funds I couldn't get returned was the 10% fee that the credit counseling agency took, from her, right? But I've also dealt and spoken with survivors, that this process with me didn't exist, okay? And they went through credit counseling, and they paid thousands of dollars in fees, etc., for this fraudulent and coercive debt again, right? But it's again, I'm going to go back to these debt advisory companies. These are people that are on ODSP, on Ontario Works, okay? And I can't think for a minute a creditor I know that would ever commence litigation against somebody that's on government assistance. But in order to get their fee, and for the trustee to know this as well, okay, and put them on a consumer proposal, okay, it is Canadian tax money that is paying the fees for these debt advisory firms and how they're making their money.
Yeah, and when someone comes in to see me and they say, well, my debts are, well, number one, I'm not working. Okay, I'm on, ODSP, Ontario Works, whatever it is. The first thing I say to them is, well, the creditors cannot garnish your wages because you don't have any. So you do not need to file a procedure to prevent your wages from being garnished if you don't have any wages to garnish. So I make that clear to them up front. And there will be some people who say, well, I expect to be working in the next few months. My family's willing to help me with this. Okay, fine. Then we can go further with that. But in the cases you're talking about, it's doubly bad because they don't have any income that would be subject to garnishment, which means no creditor is going to take them to court and sue them when they know they can't get anything. And the debts that they have could, if they were as a result of human trafficking and coercion, as you've described, they could be expunged anyways without the need to go through the formal process. So I think one of the reasons I wanted to do this podcast was so that certainly all of the trustees out there who are watching this, and most of my competitors do tune in occasionally, to make them aware of the fact that, hey, this does exist. So, okay, I'll give people the benefit of the doubt. Maybe some of them think they are helping the person. Well, here's another avenue where a formal proposal is not required, or a bankruptcy. As for the credit counseling agencies, and I think the ones you were referring to are not-for-profit agencies, I'm not going to make any comment on that because I think you said it well enough on your own. And with respect to the debts that don't go away in a proposal or bankruptcy, just to be clear on that, if you have a government guaranteed student loan that's less than 7 years since you've been out of school, it does not automatically get discharged. If you have court fines, as you described it, those also do not go away. If you have tax debt, which is what CERB is, well, if you file a proposal, it does go away. But I get your point. That was a great way to fund traffickers, and that's certainly was the minority of what happened with CERB, but it was certainly an issue. So, okay. Now, how then in real life is this going to be enforced? So let's assume that this legislation passes, right, and there is somebody who is in this situation with coerced debt and the creditor doesn't agree to expunge it. What's going to happen?
Okay. So just before we get off of the last point, though, I got to make very clear in that when we talk about credit counseling, okay? Consolidated Credit Counseling Services have been a big supporter of what I've been doing. I've been into their office with their staff, training, teaching them, etc., on how to identify suspect survivors of trafficking. And I know that they will not knowingly put a survivor of human trafficking. So, so the real, I think, ask in that area is for all the other credit counseling organizations out there to follow the lead of Consolidated Credit Counseling and start working with us, as opposed to trying to get these survivors into debt management programs. And that, so the process and this is, so the bill passed second reading. It now goes into committee where it's discussed. Public, the corporations, etc., will have an opportunity to say their piece, and then hopefully it gets to third and final reading, and it passes. At that point, any bill now gets into the regulator's hands, whatever ministry that it will, that'll fall under, and now they will work and set the guidelines of process. And this legislation calls for a tribunal process. So that, once a determination has been made that the individual is a survivor of human trafficking and the debts are coerced in that, once that decision has been made, or alternatively, no, it's not related to human trafficking and that they're not coerced debts, then either the creditor or the survivor, an individual, will have an opportunity to appeal the decision before a tribunal. Okay, and then that becomes now in the workings with the regulators, etc. Okay, what does that format look like? Okay, and very loosely, and I we haven't really talked about this. Those that are working on it, right? But, I started this with a background in banking and operational and credit. And creditors get it. And I think, to provide transparency for creditors, I think that tribunal would have to include creditors, in key roles. And that from the banking community, from the telecommunication, community, and then, a representation from, a human trafficking advocate or something that has the ability of understanding credit processes as well. I don't see, okay, and I think this would be one concern that how many cases they're going to go through the tribunal process. I don't see it as being significant. I have dealt, as I said, with many cases over the last 3 years with creditors. I do not recall a single case where I and the creditor have disagreed, for or against. The information is either telling or it's not. It's a transactional behavior, that you see on the credit card statement, bank accounts, etc., that don't mirror what you would see in a typical 18 to 23-year-old. And that's how the transaction happened. What are the underlying? And once you have that, it's evident.
Yeah, so the hope with this legislation would be once it's passed, it becomes known that, okay, this is a thing. So as a creditor, you know what? I'm just going to, evaluate it to make sure it meets the criteria, and then I'm going to wipe it out. So in a perfect world, the tribunal never hears a case.
Exactly.
We're all aware of it, and it's done. So that was my conversation with Richard Dunwoody on March 1st, 2023. We mentioned the tribunal. I want to come back to that because that's a key point. But first, as I said in the intro, it's now over 10 months later, and I'm happy to report that Bill 41 received royal assent in December 2023, and the law titled the Prevention of and Remedies for Human Trafficking Act has been amended. As I record this in mid-January 2024, even though the bill has received royal assent, it has not yet become law. The new legislation will not take effect until the Ontario government decides to make it law. But wait a minute. All parties supported this legislation. As Richard said, as far as he knows, this is only the second time in Ontario history that all four political parties unanimously supported legislation, so what's the holdup? Everyone voted yes, the bill received royal assent. Why isn't it now law? Because the devil is in the details. Bill 41 is only a page and a half long, 10 paragraphs. It looks simple, but legislation like this requires regulations to make it work. What happens if a survivor says, hey, this debt is a coerced debt, please make it go away, and the creditor says, well, we don't believe you, we're going to continue to try to collect the debt? Then what happens? Let me read again from the legislation. Subject to Section 2, in the case of a disagreement as to the application of this part of a debt, the debtor or creditor may apply to a prescribed individual or group of individuals for a determination as to whether the debt is a coerced debt. An application by a debtor must be accompanied by a letter from an organization that satisfies the prescribed criteria, setting out prescribed information in support of the application. Okay, well, that kind of makes sense. I could say, hey, I'm not paying this credit card because it's a coerced debt, and just, not pay it. There has to be some dispute resolution process. But who is the prescribed individual or group? We don't know. The government hasn't announced it yet, which is why the legislation has not yet been proclaimed into law. They are still working out the details. And this is not a trivial matter. What if I was in school and got OSAP and then was trafficked and couldn't return to school? I owe the student loan, but I didn't finish my studies, so I can't get a job earning enough to pay it back. Is that a coerced debt? What if a survivor escapes from their trafficker but has no job, and so they use their credit card for a cash advance to pay first and last month's rent? Is the credit card debt a coerced debt, even if the debt arose a few months after the trafficking period ended? Well, there are no simple answers to these questions, which is why there needs to be a dispute resolution process, such as a tribunal that Richard and I discussed. The members of the tribunal will need to understand the psychological impacts of human trafficking and sexual exploitation, but they will also need to understand how credit works. There are very few people who have expertise in both areas, so perhaps the tribunal needs to have multiple members from many disciplines. Or perhaps I'm making this more complicated than it is. The Consumer Reporting Act of Ontario, which is the law that governs credit reports, already has a tribunal, so perhaps the same tribunal used in the event of a dispute under the Consumer Reporting Act could be used for a dispute under the Prevention of and Remedies for Human Trafficking Act. Let me quote again from the Consumer Reporting Act hearing by tribunal. Where the consumer or consumer reporting agency considers themselves aggrieved By a decision of the register under this section, the consumer or consumer reporting agency may apply to the tribunal for a hearing, and Section 6 applies with necessary modifications to the decision in the same manner as to a proposal by the registrar under Section 6, and as if the consumer and the consumer reporting agency each were an applicant or registrant, except that an order of the registrar may be issued and take effect immediately, but the tribunal may grant a stay until the order becomes final. Here's my point. Bill 41 in Ontario was created to protect human trafficking survivors, and I commend the MPPs from all four parties for getting it passed. But their duty extends beyond merely passing the legislation. They must ensure that regulations protect survivors and address all stakeholders' needs. Legislation is just words on a page. Its effectiveness lies in its implementation and enforcement. Unless the government implements appropriate regulations, the intended beneficiaries may not benefit, and some stakeholders may be inadvertently harmed or overlooked. I spoke on the phone with Richard last week, and he has many of these concerns, and that's why he told me that he has reluctantly decided that he will no longer be able to directly support survivors given the potential risk they may face in the execution of this legislation. Richard's point is that we need regulations. Politicians and government bureaucrats, you're now on notice. Let's get this done. As for Richard, he'll be devoting his attention to the Concord Adex Survivors Fund. I'll put a link in the show notes. It's survivorsfund.ca. The Concord Adex Survivors Fund has provided long-term sustainable housing in 4 communities across Ontario, and I'm proud to say that Hoyes Michaelis is a supporter of this fund. All administration costs for the fund are funded by a private benefactor so that 100% of every dollar raised will directly benefit a survivor of human trafficking. That's the update. A lot of progress has been made, but I encourage the government to draft appropriate regulations to get this legislation to the finish line. That's our show for today. Links to everything we discussed are in the show notes on YouTube and on all audio podcasting platforms. Please like and subscribe. Thanks for listening and for watching. I'm Doug Hoyes. Until next week, that was Debt Free in 30.